Why disability rights laws became necessary, a brief history of special education. In this lecture, we are going to examine some of the history and legal foundations that shape special education and disability rights in the United States. It is easy to assume that students with disabilities have always had a right to attend public school, receive appropriate support, and participate alongside students without disabilities. However, those rights are relatively recent. For much of our history, children with disabilities could be denied admission to public schools, placed in segregated programs, or provided with little meaningful education. The protections that exist today were not simply offered by schools or governments. They developed through advocacy, court cases, legislation, and the persistence of individuals with disabilities, families, educators, and community organizations. As we move through the lecture, pay attention to the relationship between history and current practice. The decisions educators make today about assessment, services, placement, access, and family participation are connected to this history. Who are exceptional children? You may encounter the term exceptional children in textbooks, professional organizations, and the history of special education. Traditionally, this term has referred to children whose educational needs differ enough from what is typically provided that they may require additional services, supports, or changes in instruction. The term can include students with disabilities as well as students who are identified as gifted or talented. The number of children considered exceptional depends partly on how disability and giftedness are defined, how students are evaluated, and which categories are recognized within a particular law or educational system. This brings us to labeling and classification. Labels can provide important benefits. A disability classification may help a student become eligible for specialized instruction, related services, accommodations, assistive technology, or legal protections. A label can also provide language for understanding a student's needs and communicating about appropriate support. At the same time, labels can create disadvantages. They may contribute to stigma, stereotypes, lowered expectations, or an assumption that all people with the same disability are alike. Sometimes educators begin to see the label before they see the student. The Americans with Disabilities Act, or ADA, expanded disability protections into many areas of public life. However, the label does not tell us everything about that student's interests, culture, personality, intelligence, background, or individual pattern of strengths and needs. The challenge is not necessarily to eliminate all categories. Categories can be connected to services and legal rights. The challenge is to use them carefully. A classification should help us provide access and support. It should never become a limit on what we believe a student can learn or accomplish. Why are laws necessary? Why do we need laws specifically protecting the education of children with disabilities? The answer begins with past exclusion. Historically, many children with disabilities were not allowed to attend public schools. Some families were told that their children were unable to learn, or that public schools were not responsible for educating them. Some children remained at home. Others were placed in institutions or highly segregated programs where educational opportunities were extremely limited. When programs were available, they were not necessarily equal. Students with disabilities might have been physically present in a school system without receiving meaningful instruction, appropriate materials, qualified teachers, or access to their peers. An important legal foundation came from Brown versus Board of Education in 1954. Although Brown addressed racial segregation, its rejection of separate and unequal educational systems influenced later disability rights arguments. Families and advocates began challenging the idea that schools could exclude students with disabilities or place them in separate programs without providing equal educational opportunity. Two particularly important cases were PARC versus Pennsylvania and Mills versus Board of Education of the District of Columbia. The PARC case challenged the exclusion of children with intellectual disabilities from public education. It helped establish that these students were entitled to an education and that families needed to be involved in decisions about educational placement. The Mills case addressed the exclusion of students with a broader range of disabilities. The court rejected the idea that a school system could deny services simply because it claimed that adequate funding was unavailable. Together, these cases helped establish several ideas that later became central to federal special education law. Students with disabilities have a right to education. Schools must use fair procedures, and families must have a meaningful role in decisions. These cases also remind us that rights often become recognized only after people challenge systems that have treated exclusion as normal. Major principles of IDEA. In 1975, Congress passed Public Law 94-142, originally known as the Education for All Handicapped Children Act. It later became what we now know as the Individuals with Disabilities Education Act, or IDEA. IDEA is built around several major principles. The first principle is zero reject. Zero reject means that public schools cannot simply decide that a child is too disabled, too difficult, or too expensive to educate. Students with disabilities have a right to public education. The second principle is non-discriminatory identification and evaluation. Schools must use appropriate assessment procedures rather than relying on assumptions, stereotypes, or a single test. Evaluation should consider the student's language, culture, communication needs, and suspected areas of disability. For example, a multilingual learner should not be identified as having a disability merely because the student is still developing proficiency in English. Schools must distinguish as carefully as possible between a disability and differences related to language, culture, educational opportunity, or previous instruction. The third principle is free appropriate public education, commonly called FAPE. Free means that eligible students receive special education and related services without the family being charged for those services. Appropriate does not mean that every student receives the same program. It means that the school must offer an individualized education program, or IEP, that is reasonably calculated to enable the student to make progress, being appropriate in light of the student's individual circumstances. The fourth principle is the least restrictive environment, or LRE. LRE means that students with disabilities should be educated with students without disabilities to the greatest extent appropriate. A student should not be removed from the general education environment merely because the student needs accommodations, modified materials, behavioral support, assistive technology, or specialized instruction. However, LRE does not mean that every student must spend every minute in the same setting. The appropriate placement depends on the student's individual needs. The important question is whether the student can be educated satisfactorily in the general education setting with supplementary aids and services. Removal from general education should occur only when education in regular classes, even with supplementary aids and services, cannot be achieved satisfactorily. The fifth principle involves due process safeguards. Families have the right to receive notice, review educational records, participate in meetings, disagree with school decisions, and use formal procedures to resolve disputes. These protections matter because schools and families may not always agree about evaluation, eligibility, goals, services, or placement. The final principle is parent and student participation and shared decision-making. Special education is not supposed to be something that professionals do to a student or family. Families are members of the educational team. As students become older, their participation becomes increasingly important as well. Meaningful participation requires more than inviting someone to a meeting. Information must be understandable, family concerns must be considered, and decisions should not be predetermined before the meeting begins. Together, these principles shift the educational system away from exclusion and toward individualized access, participation, and accountability. Additional IDEA provisions. IDEA includes additional provisions that affect students and families at different ages and in different circumstances. For infants and toddlers from birth through age 2, early intervention services may be organized through an Individualized Family Service Plan, or IFSP. These services are generally provided under IDEA Part C until the child's third birthday. The IFSP focuses not only on the child, but also on the family's priorities, resources, and routines. As a child approaches age 3, the family and service providers plan for the transition into preschool services when appropriate. IDEA also recognizes related services. A student may need more than classroom instruction to benefit from education. Related services can include speech and language services, occupational therapy, physical therapy, counseling, transportation, orientation and mobility services, and other forms of support. These services are included when the team determines that they are necessary for the student to access the educational program. Another provision is extended school year, sometimes called ESY. ESY is not simply summer school, and it is not automatically provided to every student with an IEP. It may be provided when the IEP team determines that services beyond the regular school year are necessary for the student to receive FAPE. IDEA also includes protections related to school discipline. Students with disabilities may be disciplined for violating a school's code of conduct. However, when a disciplinary removal would constitute a change of placement, the school must conduct a manifestation determination. During this process, the team considers whether the behavior was caused by or had a direct and substantial relationship to the student's disability. The team must also consider whether the behavior resulted directly from the school's failure to implement the student's IEP. These protections are important because discipline cannot become an indirect method of excluding students whose disability-related needs have not been appropriately addressed. Funding and enforcement are also important. Federal law establishes requirements, but implementation occurs through state and local educational systems. Families and schools sometimes disagree about what IDEA requires in a particular situation, which is why legal challenges and due process procedures continue to shape special education practice. The right to education is therefore more than the right to enter a school building. It includes the right to appropriate assessment, individualized planning, necessary services, procedural protections, and a genuine opportunity to make progress. Related legislation. IDEA is central to special education, but it is not the only law that protects individuals with disabilities. Section 504 of the Rehabilitation Act of 1973 is a civil rights law. It prohibits disability discrimination in programs receiving federal financial assistance, including public schools. Some students qualify for protection under Section 504, even when they do not qualify for special education under IDEA. A student may need accommodations or protections from discrimination without requiring specially designed instruction. For example, text-to-speech may allow a student with a reading disability to access grade-level content. It addresses access and discrimination in areas such as employment, transportation, public services, businesses, and communication. The ADA Amendments Act of 2008 broadened how disability is understood and reinforced that the definition should not be interpreted so narrowly that people who need protection are excluded. A useful way to think about these laws is that IDEA focuses specifically on special education for eligible students, while Section 504 and the ADA are broader civil rights laws addressing access and non-discrimination. Gifted students may also require educational experiences that differ from standard instruction. Federal legislation related to gifted education includes the Gifted and Talented Children's Education Act of 1978 and the Jacob K. Javits Gifted and Talented Students Education Act of 1988. However, gifted education does not have the same federal entitlement structure as special education under IDEA. Federal gifted education legislation does not guarantee an individually designed program for every student identified as gifted. Access to gifted programs can vary significantly across states, districts, and schools. Together, these laws and programs illustrate that equal opportunity does not always mean providing every learner with exactly the same thing. Sometimes access requires additional support, different instruction, accommodations, or opportunities for greater challenge. What is special education? Under IDEA, special education is specially designed instruction provided at no cost to parents to meet unique needs. A student may also receive related services, supplementary aids, accommodations, and other supports when needed for an appropriate education. Special education is therefore not simply a room, classroom, or building. It is individualized instruction designed around a student's educational needs. One way educators describe interventions is as preventative, remedial, or compensatory. A preventative intervention attempts to address a need before it becomes a larger barrier. Examples might include early literacy instruction, explicit teaching of social skills, early communication services, or proactive behavioral supports. A remedial intervention addresses a skill or area in which a student is already experiencing difficulty. This might include targeted reading instruction, mathematics intervention, speech and language services, or direct instruction in organizational skills. A compensatory intervention provides another way for a student to access information or demonstrate learning when a disability creates a barrier, while also using a tool that provides immediate access. Speech-to-text may allow a student with a physical disability or written language difficulty to communicate ideas without handwriting becoming the primary barrier. Visual schedules, communication devices, audiobooks, and alternative response formats may also serve compensatory purposes. These forms of intervention can overlap. A student may receive instruction intended to improve a skill, while also using a tool that provides immediate access. The purpose is not simply to make work easier. The purpose is to remove barriers while continuing to support learning, independence, and meaningful participation. Educational placement options. IDEA requires schools to provide a continuum of placement options. This continuum includes instruction in regular classes, special schools, home instruction, and instruction in hospitals or institutions. Residential placement may also be provided when the IEP team determines that it is necessary for the student to receive FAPE. Incarceration itself is not an educational placement option. Students who are housed in correctional facilities may still have educational rights under IDEA, but incarceration describes a custodial setting. Rather than a placement selected by an IEP team, a student might remain in general education while a special education teacher consults with the classroom teacher. Another student might receive services from a special education teacher within the general education classroom. Some students receive part of their instruction in general education and part in a separate setting. Others may need a specialized classroom or school for a greater portion of the day. These placements are not levels that every student must move through. A more separate placement is not automatically better because it offers more specialization. And a general education placement is not automatically appropriate simply because it is less restrictive. Placement must be based on the individual student's needs. The team should first consider whether the student can be educated satisfactorily in general education with supplementary aids and services. Those supports might include co-teaching, adapted materials, assistive technology, behavioral support, paraprofessional assistance, accessible communication, or changes in how instruction is delivered. Removal from general education should occur only when education in regular classes, even with supplementary aids and services, cannot be achieved satisfactorily. Placement decisions should also be revisited. A setting that was appropriate at one point may no longer be the best match as the student develops, receives new supports, or encounters new educational demands. The goal is not simply to place a student in the least restrictive location. The goal is to provide the student with meaningful access, appropriate instruction, relationships with peers, and opportunities to participate as fully as possible. Closing reflection. The history of special education is a history of advocacy, persistence, and changing expectations. The rights students have today exist because individuals with disabilities, families, educators, attorneys, and community members challenged exclusion and demanded something better. At the same time, the passage of a law does not end the work. Schools can comply with the language of a law while still maintaining low expectations, inaccessible practices, or unnecessary separation. For educators and other professionals, being part of change may mean recognizing barriers that others have accepted as normal. It may mean listening carefully to students and families, questioning assumptions, designing more accessible learning environments, and advocating for the support students need. As you continue about your day-to-day, consider this question: how can we honor the history of disability rights advocacy through the decisions we make in schools and communities today?